Uh, Students, today we'll start discussing about Sedition Act. So all of you know that Sedition Act is a very important development that took place in the last 1 year, and also the Supreme Court suspended this act. So having the Supreme Court or having an act suspended by the Supreme Court is actually a big thing also. And not only that, there is a lot of discussion on Sedition Act. So there is every possibility that in this exam we may get a question on Sedition Act. So question could be like anything, but most probably they'll ask you, in a country where Constitution has given top priority to free speech, law on sedition has been considered as archaic, a colonial tool to suppress the dissent and violate fundamental rights. So discuss this. So what is the approach to answer this question? As I told you, some of the polity questions may also be asked as essays, and this question stands very good chance of being also asked as a part of the essay also. So how to approach this? So while writing your mains questions, one of the important aspects which I also told you in the last class that you should be doing is that you must prepare a plan for the question. You must prepare a plan. So how to approach this question? So if you look at the board, I'll write for example, you are having around 10 to 12 minutes for each question. So in this 10 to 12 minutes, the chance is that you will have to plan for any question for about 2 to 3 minutes. So in the 2 to 3 minutes, what you have to write is, like here they asked us to examine the Sedition Act. So Sedition Act, what are the major issues in the Sedition Act we have to discuss in this? That means we have to write about the advantages as well as disadvantages of Sedition Act. If there are any advantages of Sedition Act or if there are any disadvantages of Sedition Act, then that we have to discuss. So first thing is, you have to describe what is this act. That would be your introduction. So describe means rather than you describing that particular act, here what you can do is you can use a quotation. You can use a quotation to describe this act. So putting this in the mouth of somebody who is a Supreme Court judge or who is a very popular person, by doing that, your first part is taken care of. That is, your introduction part is taken care of. So you have to describe or you have to give a quotation regarding this act. Then after that, you have to describe what does this act section 124A says. So section 124A, you have to give the content of what is there in section 124A. Then you have to describe what is the recent development. So what is the recent development? In May 2022, the Supreme Court suspended the use of this act. That is the recent development. So that you must describe here. So Supreme Court told the government that anyway government, you are saying that you are ready to change this act. So till you change this act, we will suspend the use of this act, which is a what you can say, can be termed as judicial review or judicial activism, and also one of the important decision taken by the Supreme Court. So that you have to describe. So first you have to describe this act with a quotation of somebody or on your own if you want. Then what is 124A says. Then the recent development that took place in last May, that you have to say. Then now you have to come if there are any popular judgments. So there is a popular judgment in this case. So you have to write about that judgment. Then you have to describe, and after this you have to write what are the advantages of this act. So, or disadvantages of this act, whichever you want to write it first, anything you can write. So what are the advantages of this act? Is this act advantageous? You may think why should I write about advantages of this act? Because many people are criticizing it, many means majority of the population are criticizing it. Then why should we write about advantages? You should write, because if this act is not good, then why the government retained it for 73 years? Why it had changed even during the constitution making itself, but why it had retained for 73 years? Maybe there is some good side for this act. So you should not miss that good side also. So you should write that good things about this act. Then next, disadvantages. Obviously, because there are so many disadvantages, because of that reason Supreme Court has suspended it. So you have to write the disadvantages. Then finally you have to write what is the best way forward. So this makes an interesting answer. So in your answer, the examiner will look for several things, but the major aspect is the examiner will look for the basic aspects, whether you have covered all the basic aspects. Second thing is, the examiner will look if you have covered any other interesting aspects, and if you are able to put or give something which the examiner doesn't even know also, the examiner will feel very happy. Like I have read this question and I got this knowledge, or this fellow is or this person is very good writer, or he had described it properly. So the examiner may feel happy. So these two things you should keep in mind while writing the answer. So once again, this is how you have to prepare your approach. Describe the act or describe the content, then describe it using a popular quotation. Then after that you have to go into the details of what that act is about. Then you have to write about the judgment, recent development, then judgment, then pros and cons, advantages, disadvantages, then the way forward. This is how you have to approach this. So if you want, you can make a note of this skeletal approach also. Now we'll go into the question. Now we'll go into what is the answer that we have prepared for this. So I will share the screen now. So as I told you, we are starting with the quotation of an eminent Supreme Court retired judge. So he said, Madan B. Lokur said, in my opinion, one of the worst forms of curtailment of freedom of speech is charging a person with sedition. That means in this judge's opinion, or in many of our opinion also, one of the worst forms of curtailment of freedom of speech is sedition. That means, what do you mean here? What does he mean here? That means by using this act or by applying this act, the government or the authorities are trying to stop or affect the freedom of speech and expression. So that is one major disadvantage of the Sedition Act. Now second part, like what is the recent development? The Supreme Court on May 11, 2022 directed the center and states to keep in abeyance all pending trials, appeals and proceedings with respect to the charge framed under section 124A of IPC, which deals with the offense of sedition. So what the Supreme Court is saying, you suspend this act. When, up to what time? Till the central government completes the promised exercise to reconsider and re-examine the provision. So central government, if you recollect during May, what the Supreme Court and central government, what happened between central government and Supreme Court? Supreme Court to ask the central government, would you want to change this act? initially central government said, no, we don't want to change this act because we feel everything is fine with this act. But within a couple of days, the central government again came back through the Attorney General and told the Supreme Court, yes, there are some defects in this act and we will change it, so please give us time. Then Supreme Court said, okay, how much time you want? So till you modify this act, we are going to suspend the use of this act. So that is what has happened. Then, so by using this act, what the government is doing, or what various governments did, what they did was, they are actually affecting the fundamental right of freedom of speech and expression. So how they are doing it? So now observe the act. Section 124A says, whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring hatred or contempt or excites or attempts to excite disaffection towards the government shall be punished with imprisonment for life, or fine may also be added. So which means it simply says that if you criticize the government, you will be put behind bars, or if you hold an opinion against the government, you will be put behind bars. So that is what the act says. That means if you criticize the government policy of Narendra Modi or KCR or any chief minister or any government, immediately you may be put behind bars under this act. So that is why it is called as an archaic act. So this act was challenged initially in the early independence time itself. This act was challenged, and when this was challenged, the Supreme Court, a 5-judge constitutional bench of the Supreme Court, gave a ruling on this act. What the bench said? The bench said this act can stay, but the bench said that anybody can criticize the government, but that criticism should be limited. To which extent? If that criticism is causing violence. That means if you criticize the government, or if you put a post against the government, or if you say something against the government, and if that is creating violence, then only you should be arrested. Otherwise, you can criticize the government. Otherwise, you should be allowed to criticize the government. Until what time? Until the time it creates violence. Till that period, you should not be stopped from having an opinion against the government. Like yesterday, last class I told you, the Chief Justice of India said dissent is the most important safety valve of democracy. So without dissent, democracy cannot perform. That is why in the Kedarnath ruling also the Supreme Court said this act may be used to arrest anti-social elements like terrorists, Naxals or somebody else like that, but not common public. Common public are entitled to criticize the government, hold an opinion against the government policy. So they should not be at any cost be arrested using this act, because without criticism, democracy cannot survive. So what the government is doing? The government is arresting people who are against the government, and in most cases the case is not being proved. That means the case is being defeated in the court, but by this time this fellow will go to jail, spend some few months in jail, and he will come out walk free. But but you already lost a few months to jail. Living in jail or staying in jail even one day is a painful experience. So what the governments are trying to do, boss, we will arrest you under this act. We know you will come out, but when will you come out? After 3 months, 4 months, 5 months. So better behave, don't criticize us. That is the attitude that government is having. Like in hundreds of cases, the conviction rate is not even 1%. That means the real Sedition Act should be applied only on the 1% people. but many people are being arrested. That is why there is a lot of discussion on this act that it has to be scrapped or even modified. Supreme Court also had the same opinion that it has to be modified. So now coming back to this. So here if you observe how we constructed this question with an introduction, then with a description, then with a court case, then now we are writing about criticism as well as arguments in favor of this act. So criticism, I had given 6 points here. So what are the top points of criticism here? Many Indian leaders like Mahatma Gandhi and Bal Gangadhar Tilak were booked under this law. This law is of colonial origin. That means the British people enacted this law to control our independence movement or to suppress dissent or freedom movement of the Indians. So why should we have this law? So you can argue like that. Then this law is of colonial origin. In a liberal democracy like India, such type of laws should not have any place. So in a liberal democracy like India, we should immediately scrap these kind of laws. Then third point, this act will suppress the most precious right of democracy. What is the most precious right of democracy? Right to freedom of speech and expression. So that will be suppressed by this act. Then fourth point, the act is being used to suppress criticism of the party in power. So the party in power will be ruling the country and it will be the most powerful unit or it will be the most powerful organ. So that powerful organ is using its power to suppress criticism. Fifth point, the offense under this act is non-bailable and makes it difficult, like I told you a few minutes back. So because it is non-bailable and it is very difficult to get bail, so immediately you have to sit in jail for 3 or 4 months. That is what the government is trying to threaten you, saying we know you will come out, but when? After only 4 months. Then next one is the gradual erosion of right to freedom of speech is adversely impacting the liberty of all those who dare to speak. So it is suppressing the voice of dissent. Who wants to speak against the government, they are being completely suppressed. So like this, these are some of the points that you have to put here. The next one is arguments in favor of this act. As I told you, we must give certain things which are in favor of this act, because there were so many governments, but so many governments have not changed, and there are 17 Lok Sabhas so far. 16 and 17 is running now. So these 16 Lok Sabhas have not changed this act, which means that there may be some good things about this. What are those? First thing is, freedom of speech and expression is not absolute. That means your freedom of speech must be exercised adhering to certain limitations. Thus, sedition is a reasonable restriction. Then, Supreme Court in the Kedarnath case said that seditious speech and expression may be punished if it creates public disorder or violence. So thus the problem is in implementation and not in the law. So the law is clear. So the law is having certain ambiguous points, but that ambiguous points were cleared by the Supreme Court. So how it was cleared by the Supreme Court? Supreme Court clearly said this law is not right. Sorry, this law is not wrong. This law is right. But you have to arrest people only if violence is created. So which means the law is fine, but implementation is not fine. Since India faces several extremist challenges, such a law is needed to put these anti-social elements behind the bars and silence them, and also to prevent spread of violence and protect the country. So to tackle violence and emerging challenges, police need to be armed with such kind of tough laws. So we are defending here but criticizing also. So the point what we are making here is law is may not be bad. Implementation or the implementers like the government, the police, they are not using it properly. So what is the best way forward? While it is important for each of us to exercise our fundamental rights, reasonable limits must be followed. It is time for the establishment to realize, establishment means government, to realize that people of this country mean well, which means they are very good people and they want very good things to happen and they desire so. So in a democracy, there are bound to be different points of opinion. That means you must respect the opinions of the people. Like several thinkers said, 100 people may be having one opinion. One person will be having a different opinion. So you must encourage that person with different opinion to tell his opinion. Sometimes that opinion may be correct and majority opinion may be wrong. It happens so many times. That is why you must respect people, or you must encourage people to have different kinds of views. Then, if you don't do it, the fabric of our society might disintegrate, and fraternity, one of the key elements in the preamble of our constitution, may not be followed properly. Then India of the 21st century does not require a law by colonial government, because this law is suppressing India's voice. So the guidelines of the SC or the Supreme Court must be incorporated in 124A. They have to amend this act. We are saying, in conclusion, we are saying they have to amend this act and Supreme Court guidelines must be there, which clearly said that only after violence is created, arrest the person. So this will ensure that 124A of IPC strikes a beautiful balance between security and smooth functioning of the state with fundamental right of freedom and expression. That is how you must end this caution. Like again, if you look at the document which you are having, there is a quotation, Supreme Court description, then description of this law, then again Supreme Court so old description of this law, then two things, criticism of this law a few points, arguments in favor of this law a few points, then finally the way forward. Like this, if you write the answer, tell me how the examiner will refuse to give marks. So this is how you have to prepare and you have to write the answer like this. So we'll be discussing a few questions like this, but we have a proper course in place where all the dimensions of polity will be taught there. So you, for other details you can call us, and also we'll also give you a notes like this kind of notes. We'll also be providing you if you are interested. So this is how you must write a answer. This is how you must approach a particular question, and this is also a very important question for the exam. Okay, and we'll come up with another question in a couple of days. Thank you.